She's the author of Illusions of Security, Global Surveillance and Democracy in the Post-9/11 World. Maureen is the co-chair of the International Civil Liberties Monitoring Group, a founder of the International Campaign Against Mass Surveillance, and a director of Lawyers' Rights Watch. She's also the mother of 2 small children, and we're very grateful that she's given her time so generously to come to Vancouver to speak to us tonight. So can you welcome her? Maureen?
The title of my lecture tonight is Security Integration and Rights Disintegration in the Post-9/11 World. Since the terrorist attacks of 9/11, the Bush administration has been pushing countries to integrate their policing, security intelligence, and military functions with those of the US. National governments have been complying, throwing aside sovereignty and existing checks and balances in favor of a security space that's largely being designed and controlled by the US. And Canada, our dear country, has been in the forefront of this trend. In the process of this integration, a whole web of laws, norms, and protections have been affected. Canada's obligations under international humanitarian law, its obligations under the Convention Against Torture, the Convention on Refugees, the International Covenant on Civil and Political Rights, its extradition regimes, its privacy and data protection regimes, its constitutional protections like the right to due process and security of the person, freedom of expression, freedom of association, freedom from unreasonable search and seizure has been affected. Our criminal code regime has been affected. Our Canadian Evidence Act has been affected. And our due process and fairness protections under administrative law have been affected, and other areas as well. And tonight, what I'm going to try to do for you is to map out the process by which we were moving in the West from an age of rights to an age of terror, using Canada as a case example. From an age of rights to an age where so-called security concerns trump everything. Now, though there's important antecedents going back to the Magna Carta and beyond, the Age of Rights in the West began in earnest during the Enlightenment. And this was a time when ideas about the natural, inalienable rights and universal rights of man were first enshrined in national constitutions. It was a time of great optimism with a burgeoning faith in scientific process and progress and humanism. And it was the time when, as I said, the domestic content of our human rights protections was largely developed, so that the protections that we take for granted in our criminal law, our constitutions, our administrative law, our privacy and other regimes are something that we've struggled for and developed over centuries in the West. This age of rights was accompanied and informed by the establishment of democratic forms of government. And there's a profound relationship between the ideas of rights and Western liberal democratic forms of government. As I said, the Enlightenment was a time of great optimism, when people began to put their faith in human reason to make sense of the world. And the idea that reason was a capacity that was possessed equally by men was really a deeply radical one at the time. It led logically to the idea that all men were equal. It conferred on man a special moral status and dignity. And it suggested logically that there was no natural sovereign above men. So that in the liberal democratic tradition, governments exist for and at the pleasure of the people. The government is answerable to the people. And moreover, the government is answerable to the individual. The individual is to be treated as an end, never as a means. and the individual has claims as of right on the rest of society. Society must mobilize itself to ensure that those claims are met. And though these rights are not always absolute, they are of sufficient force that they often trump purely utilitarian calculations about what might otherwise be in the interest of the majority. The Age of Rights in the West deepened and widened with the advent of the Second World War. Until the late 1930s, the international political system and international law continued to maintain that how a state treated its inhabitants inside its borders was not a matter of legitimate international concern. But with World War II and the mounting evidence of atrocities in Germany and in the countries it occupied, how Nazi Germany treated those under its rule became a matter of acute international concern. And with victory, the Allies drafted the Nuremberg Charter, one of the first human rights instruments under which the Nazi leaders were charged with the new crimes of waging aggressive warfare and crimes against humanity. At the same time, the Allies drafted the Charter of the United Nations, which prohibited the use of force, military force by states, except in self-defense or with the approval of the Security Council, and declared the promotion of human rights to be one of the primary goals of the new organization. A UN Commission on Human Rights was set up, and one of its first tasks was to draft the Universal Declaration on Human Rights, which was a seminal document in the development of a new international human rights movement, and something that Canadians in particular can be proud of because one of our own, John Humphreys, was one of its principal drafters. All of this constituted a new world order which was meant to guarantee both global and human security. And it is this world order, along with our older democratic rights regimes, which is disintegrating as our governments succumb to US demands to integrate our security policies with its new vision of the world. I said we're moving from an age of rights to an age of terror. And of course, the age of terror is what the Bush administration, and make no mistake, the Democratic and Republican candidates for the current race for the presidency, would have us believe that we are living in since 9/11. An age when sophisticated transnational networks of Islamic terrorists pose an unprecedented and even existential threat to our free societies and world peace. That's what they would have us believe. I don't believe that most Canadians think that, though. And I would quite sure that you would not be surprised if I told you that US State Department reports themselves show that between 1995 and 2003, the total number of people killed by terrorism globally each year, the average number was under 800. That's including the 9/11 attacks. And while no death caused by terrorism is acceptable, the numbers, even when inflated, are minuscule compared to the 1.2 million people killed yearly in car accidents, and compared to the truly existential threat, not just to our nations, but to our species, posed by global warming, a threat which governments are doing comparatively little about. But, you know, in difficult times, ironies abound. In many ways, the era that we've entered since 9/11 is an age of terror. An age where an individual at any time may be presumed guilty and blacklisted from a job, dragged out of line, denied the right to travel, listened into, detained, and even kidnapped and tortured, without ever knowing the allegations made against him or the criteria by which he is being judged. It's an age where the individual is answerable to the state, not the other way around, and in which our societies are increasingly being governed in security matters by executive fiat rather than by deliberative houses of government. It's an age of the widespread use and official acceptance of torture, of legal black holes, an age of new large-scale detainment centers being built in the United States, of DNA databases being set up to register ordinary citizens, of centuries-old protections being suspended in permanent states of emergency, and an age of preemptive warfare, where the UN Charter restraints on the use of force have been brushed aside and in which there are seemingly no limits on the strong, the use of force by the strong. In short, we are entering an age where the most brutal utilitarian calculations trump rights and even the rule of law and democracy. I think there's just so much to be said about what is happening in the US, the UK, Asia, Latin America, developing countries that can be said to illustrate my thesis tonight. And even limiting our discussion to Canada, there's an enormous amount to cover. But perhaps a good place to start is with the Smart Border Agreement and accompanying action plan. This was an administrative agreement which was negotiated between John Manley when he was our Deputy Prime Minister and Tom Ridge, who became the head of the Department of Homeland Security in the US. And in many ways, it's the blueprint for security integration with the US. There's three things I'd like to note about it. First, it's premised on the idea that governments have to preempt future terrorist attacks. Now, this idea of preemption is ubiquitous today, and at first blush it seems like a reasonable goal. But in fact, it's become the mantra of governments, the mantra that governments use to justify their incursion on our rights. And it's a very dangerous idea because, as we see with the doctrine of preemptive war, it can be used to justify just about anything. The second thing that I'd like to note about the Smart Border Agreement is that it's not legislation, it's not a treaty, it's an administrative agreement. It's never been reviewed or debated by Parliament. And much of what has been put in place since 9/11 in terms of security has been implemented in this way. Off the radar screen of the public, outside of normal democratic processes, through administrative agreements, through international forums, regulations, international working groups, and sometimes in secret. And the third thing to note is that the Smart Border Agreement and its progenitors and its antecedents and its those documents which came after it revealed the special role of the corporate lobby in pushing integration, security integration in Canada. Now, there's many reasons why various countries are acquiescing to US demands for integration, and I can talk about that more in question period if you want. But in Canada, it's the corporate lobby which has been the most vigorous proponent of security integration with the US. And I've heard various figures, but one is that 30% of our economy depends on trade across the border, the US-Canada border. So of course the corporate lobby does not want to see that border closed down or slowed down due to US security concerns. But they also see the current security preoccupations of the US as a golden opportunity to push for the customs union and the social and regulatory union that they have been wanting all along. And John Manley has been a key proponent of these goals, both in and out of office. So what does the Smart Border Agreement and Action Plan call for? Well, it calls for common biometric standards for identity cards that can be used across different modes of travel, coordinated visa and refugee policy, coordinated risk assessment of travelers, integrated border and marine enforcement teams, integrated national security intelligence teams, coordinated terrorist lists, new counterterrorism legislation, increased intelligence sharing, and interestingly, joint efforts to promote the Canada-US model internationally. So let's unpack what this means for the disintegration of rights in Canada. Everybody in Canada has heard about the case of Mayor Arar. And for most of us, it's a striking example of how the rights of Canadian citizens have been compromised in the US war on terror. Well, the RCMP's Project AO Canada, which focused on Ahmed Almaty in Toronto and on Abdullah Al-Malki and Mayor Arar in Ottawa, was an integrated security intelligence enforcement unit, or a team, an inset operation of the kind called for by the Smart Border Action Plan. And the ultimate inquiry into the case of Mayor Arar illustrated the kind of intelligence sharing that goes on in these teams and generally in the new security paradigm. The RCMP met regularly with the FBI and an agency which we believe was the CIA. And it turned over its entire unedited investigation file to these agencies. It burned them into a number of CD-ROMs and just turned the whole thing over. The RCMP in the inquiry said that they had been given a preemption mandate. They were told not to hold anything back, and they didn't. They gave a lot of misinformation and sloppy information about the Arars to US agencies, and contrary to existing protocols, they turned it all over with no caveats about how the information was to be used. These inset teams, which are still operating in Canada and which are also set up in the EU, allow US agencies to share information directly with their host country agencies without the formal state-to-state requests that are normally required under mutual assistance treaties. And US agencies are not accountable to national host governments or national host courts. As it turned out in the Arar case, this is a recipe for the violation of citizens' constitutional rights against unreasonable search and seizure, the right not to be deprived of security of the person except in accordance with fundamental justice, the right to counsel, the right to habeas corpus, and rights against arbitrary detention, torture, and inhumane treatment. Canada proffered him up to the United States, and the United States did what it wanted to Mayor Arar. And as Canada has integrated its security functions with those of the US, there's evidence too that Canadian agencies have been drawn into the same kinds of human rights abuses as the US agencies. In the Arar inquiry, it was revealed that the Canadian ambassador to Syria acted as the liaison between the Syrian military intelligence that was torturing Arar and other Canadians, and the RCMP. And moreover, it was held that the ambassador and the RCMP must have known that torture was taking place. And in the Al-Malki, Al-Mahdi, and other Canadian cases, the RCMP and CSIS have been accused of practicing a kind of rendition light in which they've waited for Canadians to travel to jurisdictions where they know that torture and arbitrary detention take place in order to tip off local authorities and have them detained there. Now, the Convention Against Torture, to which Canada is a signatory, requires that countries not expel, return, or extradite a person to another state where there are substantial grounds for believing they would be in danger of being subjected to torture. And, you know, in its practices, Canada might have skated very close to the edge of actually violating that obligation. But at the very least, it was complicit in the torture and perhaps even guilty of violating the Section 7 rights of those Canadians, their rights not to be deprived of security of the person except in accordance with the principles of fundamental justice.